Welcome to Candid Conversations for Financial Markets podcast series. I'm your host, Laura Paglia, President and CEO. Our podcasts are designed to provide insights, transparency, and provocative yet achievable proposals for matters that move financial markets in Canada. A quarter century after the Personal Information Protection and Electronic Documents Act, PIPEDA, reshaped Canada's privacy legislation, Ottawa is proposing a sweeping overhaul. On June 15, 2026, the government introduced Bill C-36, legislation that would replace the private sector privacy framework established under PIPEDA with a new regime, Protecting Privacy and Consumer Data Act, the PPCDA. In this episode, we're going to focus on the practical considerations arising from the proposed new act and what organizations should be paying attention to as this legislation moves forward. Our guest today is Stephen Burns, partner and co-head of the Innovation Technology and Branding practice at Bennett Jones. Stephen advises clients on privacy, artificial intelligence, data governance and compliance, cybersecurity, social media, and complex technology transactions. He regularly appears before Canada's Information and Privacy Commissioners. He is widely recognized as one of Canada's leading privacy and technology lawyers and is a member of the Steering Committee Working Group 13, Artificial Intelligence and the Law of the Sedona Conference. Stephen, welcome to the podcast.
Hi, Laura. Thank you for having me.
So, Stephen, if you had to explain Bill C-36 to a board or an executive team in 1 minute, what's the key risk and what's the key opportunity?
So that's a great question. It's a great place to start our conversation. If you look at the risk, the new legislation, and I'll answer the question first, then we'll talk about the legislation. If I look at the new legislation and what it proposes, it really modernizes the federal private sector privacy legislation, bringing it into alignment with the Alberta, British Columbia, and Quebec private sector privacy laws. So it'll be much easier to review. But from a risk point of view, what they've done is they've proposed that we will have real enforcement powers, real documentation requirements, and real oversight mechanisms. And as we go through our conversation, I'll explain what those risks are. But what it really drives to is the commissioner will be able, or the commission will be able to impose fines that are significant and to order you to come into compliance with the legislation. And the legislation will drive you towards more documentation, more process, and more privacy by design, more privacy consideration in how you operate your business. The flip side to that increased compliance work, however, is a real opportunity that I want to sort of flag as we go through the discussion. By modernizing the privacy legislation, the federal government is giving every organization in Canada to which the legislation would apply an opportunity to step back, look at where is their data, how are they using it, what tools are they engaging with it, and are they achieving the outcomes they want? Because while privacy is about ensuring that data flows through an organization for a reasonable purpose to the extent necessary to meet that reasonable purpose, it really, to be able to do that work, forces the organization to think about all of their data. And I think the opportunity that it offers to be able to step back, understand my data, my tools, and my outcomes is a really good opportunity to also consider how artificial intelligence might come into the organization to improve a data process, to think about security, to think about cost of delivery, to think about resiliency and reliability. All of those criteria that let us drive out costs and improve a return on the investment in our data processes and our IT systems. This gives you an excuse this gives you a requirement to go in and have a look at those from a privacy perspective. But while you're looking at it from a privacy perspective, you might as well have a look at it for all the other reasons one should have a look and potentially really use it as an opportunity to drive some value generation in the organization. So while on the one side, modernization of the federal legislation is good and is going to drive some better outcomes for Canadians, it may also be used to be able to drive some better outcomes for the organizations if they embrace the compliance activities as the opportunity to take open up the hood, look under it, and maybe fine tune the engine a bit.
Thank you, Stephen. Why is the government moving on this privacy overhaul now?
So, when you step back and look at what's sort of going on in this package of legislation that Minister Solomon bringing forward, for the first time, Canada has a Minister of Artificial Intelligence. That is a huge statement about Canada's commitment that we've created a ministerial position focused on artificial intelligence as part of his mandate. As part of that, he's looking at data safety, supporting artificial intelligence companies, developing our AI capabilities and the resulting productivity gains that will come from that. He's also looking at managing and aligning and modernizing our legislation so that we can accelerate those activities and we can reap the benefits of this change that's going on, driven by artificial intelligence. You see that in this piece of legislation through issues like the de identification and anonymization rules, which allow you specifically to take personal information, anonymize it, de-identify it, and then use it for the purposes of a legitimate purpose to drive development of an AI tool, for example. You see this in the automated decision-making uh, wording in the legislation, which we'll come to in our conversation, which talks about if there's an automated decision system is used and it has a potential impact on an individual, then the individual should have some transparency around what that decision was, how it was made, and how it's going to come along. So it's a balancing of recognizing that we're in this new AI age and we need to bring a bunch of legislation forward. There's other legislation that's coming forward, the Digital Safety Act, which is addressing the protection of children, the protection of against deep fakes, against a set of harms that are listed. So I think what you're really seeing is this sort of package approach by the government of we want to take AI seriously and we want to take benefits seriously, and that means we need to upgrade the legislative framework so that we have a clear and a fair playing field for all the participants to understand how that's going to go forward.
Okay. And this proposed act would apply to whom?
So, under the federal, so Canada, of course, has a federal government and has provincial governments, and our constitution divides powers between the two parties. The federal private sector privacy legislation is based on commercial activities. It's the trade and commerce power. So, where the province has the ability to regulate privacy directly, the federal government has to do it through trade and commerce. So they have applied it so it affects the collection, use, and disclosure of personal information in a commercial activity occurring in Canada. So there has to be a commercial activity element to it, and to federal works, undertakings, and businesses.
Okay.
Right. So where the feds have sole jurisdiction versus where there's a combined provincial jurisdiction, and it's important to note that the federal jurisdiction will cover what happens in a province unless there is substantially similar privacy legislation enacted in that province. So BC, Alberta, and Quebec have their own legislation, and those legislation will apply in those provinces. But once the data goes across a provincial border or across a national border, then you will also have the federal legislation applies. And this is really important in the context of this legislation. Canada is complex. And
Mhm.
because of that complexity, as an organization, you need to consider usually not just the legislation of the province that you're in or but also the other provinces where you may be collecting, using, and disclosing information, and as well the federal jurisdiction. So Your program and your process of privacy is one of understanding and complying with all of those pieces of legislation that might apply to you. And so harmonizing and modernizing the federal legislation so it more closely aligns to the wording across the provinces makes organizations' lives easier. It gets rid of some of the ambiguity and confusion that existed under PIPEDA.
Um, how else is this proposed legislation different than PIPEDA?
So firstly, it's a much easier read. It's a much cleaner piece of legislation to deal with, and that will make lives easier for organizations. Secondly, it replaces PIPEDA. So PIPEDA is going to the Personal Information Electronic Documents Act splits in two. The privacy elements gets replaced by this new legislation, and the electronic documents elements will continue along, but that legislation is going to be renamed. Where it changes things are currently the federal privacy commissioner doesn't have a real order making power and has very limited fine making power. Now we're going to see a commissioner and a commission with real order making power, real fine capabilities, real enforcement capabilities. We're also going to see new areas covered. So there is an emphasis now on better documentation, on addressing artificial intelligence through the automated decision making and the anonymized and de identified elements. There are new rights, the rights of disposal, the rights of data mobility. There are nuances. But if I stood back and looked at the core fair principles upon which most privacy legislation in the world is based, it's pretty much the same. It's still a consent based model where you as an individual have the right to know what information is being collected about you and how it's going to be used. And you have the right to expect that information is going to be used solely for those purposes, that there's going to be transparency and accountability, that that information is going to be safeguarded, and that you'll have the ability to access and understand how that information is used. So, in many ways, it's um, the core is the same, but it's clearer, and now it has better enforcement capabilities, better um, an additional layer to address the modern world. So, if I was to stand back to my as we very started the conversation, we modernize it. We have real powers for enforcement and compliance. We address the and create a level and clear playing field to support the development of AI change. And we, in some cases, put power in the hands of individuals. At the federal level, there will now be a private right of action following a finding that that there's been a breach, like a sort of a final determination that there's been a breach or a fine or penalty imposed, then individuals will be able to seek damages accordingly.
Stephen, the legislation recognizes privacy as a fundamental right. Um, have you described in practical terms what that means for the organizations that are subject to the legislation, or is there more?
So there's been a lot of discussion amongst in the case law and from the commissioners about where privacy ranks in sort of order of importance when you're considering how to apply the law.
Yeah.
And by saying that it's a fundamental right, we're saying that if there's two competing questions at law, then the fundamental right will go first and it will be given precedent over the other elements. It's really a statement that if there's ambiguity, then we'll find in favor of privacy. We've seen that already in a number of the cases and commentary and discussions. There shouldn't be anything particularly shocking in that statement as a Canadian. But what I think it does is it highlights that the legislation has really been updated to think about areas where there was gray in the predecessor PIPEDA and sought to resolve that with the black and white of clear words in the legislation. So it stops the debates, it stops the possibilities of an argument, and lets us focus on delivery of a privacy compliant and privacy respectful sort of commercial world. And I think that creates certainty, right? I think when you think about it from an organization's point of view, the last thing you want is gray. You want certainty so you can make a decision and you know that the decision you've made brings you into compliance and you're not either spending money on something that you shouldn't have or not spending money where you should. Gray doesn't make easy investment decisions in a process where, in many cases, privacy is not really a profit center for an organization, it's a
Yeah.
compliance cost. And
Yes.
so when you're competing for resources to in a compliance cost basis, it's a lot easier to just be done with it and make the right decision if it's set out in black and white. So there's a number of spots in the legislation where the government's taken the time to close some of those gray loopholes or some of those gray areas, not loopholes, gray areas that will, I think, give better guidance to organizations and make it less expensive and less agonizing around some of the decisions you have to make about how you're going to design how your data, tools, and outcomes work.
You mentioned the private right of action. Um, how does it work in practice? And in what are the common circumstances that we can expect that individuals may bring a claim for a private right of action?
Well, I think it's important at this stage to note first, this is draft legislation that was introduced on June 15th,
Yes.
and we're not even at second reading. So
Mhm.
it's at first reading, which means it was introduced. It'll get to second reading, and from second reading, it will go out to committee. The committee will study the legislation, may have an opportunity for feedback and comment, and the legislation may evolve. So I don't want to get too far down into how the details will work because we don't have certainty yet. The second thing we don't have certainty yet around are the regulations that follow. So a number of portions of the legislation create um, guardrails but not detail of the space between the guardrails. So it will say you can do this as long as you follow the rules as prescribed. And those prescribed rules aren't available yet because we don't have the draft regulations. So I think we want to be careful in getting too far ahead in understanding how it works. Now, that said, let's answer your question. On the private right of action, I think the most important part about the private right of action is I didn't have it. Anyway, that it currently provides that for certainty, the private right of action does not limit or affect an individual's right to avail themselves of any civil remedy under another act of parliament, under an act of a legislature of a province, or at common law. So the private right of action is an addition to, but does not replace any other actions you might have under a privacy act, for example, in British Columbia, or under the common law, such as we've seen some of the torts of privacy now being accepted and brought into Canadian law. What it does is it provides you a right to claim damages because of a breach of the legislation, or whether it's a breach or whether it's because of a fine imposed. There's a tight legal issue there. Let's just say just breach the legislation for simplicity. If somebody doesn't comply and they're found not to comply and you suffer damages, you now have a clear course through this legislation to go and get those damages. Similarly, you could still have gone and gotten those damages under all the existing common law and other pieces of legislation. So it's an add-on. What this makes me sort of think about is where before you might have this sort of approach that there's very little damages, it's hard to show what the damage was, the dollar amounts are quite low, is how will this right sit within all the other provincial and common law rights? And how will this work in respect of class actions?
Yes.
Right? And I think what you end up looking at is where my right of my damage might be quite minimal in privacy, five, $10,000. But if there's a million affected individuals, now you may have a cleaner venue to bring that suit with um, the ability to say, you breached, I have damage, now you pay me. Instead,
Mhm.
you had a duty, you breached that duty, I have damages, now you pay me. It's a cleaner pathway toward
Mhm.
recovery, but these are very early days, and that's a highly speculative comment. Um,
Mhm.
and so I don't want anyone to, we'll know more as this develops. But it's a great question.